£2 million is a huge amount of money, so it's not surprising that when Christine Gill found out that her mother had left that amount to an animal charity in her will, she decided to go to court to fight for a share. And she's not alone. More and more people are now rowing over wills. Last will and testament, a document that states your final wishes, except that isn't always the case. There have been hundreds of cases of families so disappointed with their relatives' wills that they've been prepared to risk thousands of pounds taking their fight to court. But if you want to leave all of your money to the cat's home, surely that's up to you. If a will can be successfully challenged, then what's the point of writing it in the first place? Christine Gill helped run the family farm. She always assumed her parents would leave it to her, but when they died, to her horror, she discovered they'd left everything to charity.
They'd left everything to each other, and then when the last one died, everything was to go to the RSPCA. And there was a sentence in it excluding me on the grounds that I'd been well provided for in their lifetime. And that was it. I don't know why he made that will.
But you hadn't fallen out with either of them?
Oh, no. No, and that was the crazy thing. And that's one of the most hurtful things when I found out about the will, because it was as though a veil had come down over all my past life, and it all suddenly became confusing and unexplained.
Christine decided to fight the case in court. Her story is not uncommon. Many solicitors now offer seminars about inheritance.
The validity of a will can be challenged on a number of grounds, but today's seminar is going to focus on disputes concerning wills that are perfectly valid. And that's what the Act.
Amanda Smallcombe is a partner with Colchester solicitors Birkett Long and specialises in contentious wills.
Since 2006, the number of cases that have been issued are increasing. It certainly makes up the whole of my caseload now. I think there's a general trend that people expect to receive an inheritance, and there are a lot of people that come in to see me on the basis that it's just not fair that they've not been provided for, and they think that they can bring a claim because it's just not fair. There are significant legal costs in bringing a challenge to an inheritance. It's a complex area of law, and therefore the legal fees can be high. Very often thousands of pounds, sometimes tens of thousands of pounds, sometimes hundreds of thousands of pounds. But there's also an emotional cost. People are dealing with the death of a loved one, and they are also often warring with other family members. And in that respect, I think these cases are worse than divorce cases.
One reason for the increase in challenges to wills is the rise in the number of complicated families. Graham and Gwyn Hart from Chelmsford attended the seminar because they both have children from previous marriages and they want to avoid any arguments after they die.
We wanted my money to go to my children and Graham's money to go to his children. So that was always been in the back of our minds. We want it sorted out. We don't want them to have the aftermath of having to sort things out. It's not easy to do the right thing every time, by everybody and for everybody. So I mean, that's why I think it's up to us to sort it out ourselves, beforehand. We shouldn't leave them that mess to sort out.
If my wishes weren't carried out, I'd be very sad if that caused problems in the family, but I'd be really angry with myself for not making it completely watertight.
Wills can be challenged for a number of different reasons. Not written properly, not signed, but also if they don't provide for a child. So if you really want to exclude someone from your will, can you?
It is possible to try and exclude a child from a will. The best thing for somebody to do who's making a will is for them to write a letter to be kept with the will, explaining the reasons why they've left their child out of the will, and to review that letter on a regular basis, say for example every 2 years.
And if you decide to challenge a will, you may risk everything. Christine Gill used her savings and mortgaged her house to hire the best solicitors she could afford to take on the RSPCA.
When you take on an organisation like a big charity, they've got resources behind them, and they get the best lawyers, the best solicitors. Quite early on, this house was put at risk, and if we had lost the case, well, I wouldn't be living here. I'd be destitute. If you're going to try and challenge a will, as I did, you can't just go along and say, well, I don't think this is fair. Because the law doesn't bother about fair, it bothers about fact. You need evidence. And I was fortunate in that I had lots and lots of evidence. I had documentary evidence. I could prove the things that I was saying, I could prove with pieces of paper, which the courts like.
Writing a will is one way of deciding what happens to our loved ones once we're gone. So if you're thinking of excluding a relative, it may be best that it's not a complete surprise. After a 4-year legal battle, Christine won her case and got her inheritance, but she just wishes her parents had told her what they had intended to do.
If people want to give money to charity, or if they don't have relatives that they want to leave money to, well, why shouldn't they? But I think if they'd told me in 1993 when the will was made, then I could have made appropriate decisions about what to do with my life.